take pot shots at me. I'm a witness now. I'm complaining. Now that gives them the authority to get the warrant based on my witness and go there. So yes, it is a terrible problem because you have government posing itself as a victim on behalf of whoever, I don't know. And who has been hurt? Who's been hurt?
The little people.
Yeah.
My turn?
Yes.
Okay. I had a comment for the travel guy. One is the very first case that dealt with driving versus whatever. The guys set up their case. They set up their case. They stipulated to all kinds of stuff that weren't true. Now, what he said was, you set your case up. I'm working with Pat Patton trying to set up a case. The same with Rosa Parks when she did her deal with the equal or the affirmative action. I can't remember what it was. Where she was on the bus. They set that case up. If we want to win cases, we've got to set them up ourselves so that all of the facts support us. And I think that's what you were saying earlier.
Exactly, exactly. You've got to empower that court to make the decision that you want to make for you.
Okay, now I got 3 questions. One, if a person were to fail to appear, the judge issues a summary judgment, could that person later attack that judgment as void?
Absolutely, absolutely, unless they've got that 4th leg on there. They've got to have the jurisdiction, because it's just like the surgeon operating. There's got to be the tumor there to remove.
Okay.
Otherwise, it would be a fraud on its face.
Okay. These next 2 deal with me personally. IRS agents act outside of their authority.
Mm-hmm.
I take them to state court. The U.S. District Attorney, I assume, would then try and get it into federal court. Do you know of a way to put your pleadings in so that you can prevent that, or is there a way?
I don't have specific experience with that, but I know that the United States Supreme Court made a decision.
Was on a summary judgment for a 2039 summons to get books and records. I had a case where the U.S. Attorney got up, talked to the judge. The IRS agent entered a declaration. I never had the chance to cross-examine. I told my side of the story. The other attorney told his side of the story. As far as I could tell about what you're saying, no evidence was entered on their part, yet they ruled against me. Is my best option to then file a new case? You said collaterally attack in the federal court?
In the federal, you have to do it by motion. I think it's a 60E, but I would definitely do that. And you can actually rely on Vern Holland's recent case where the 10th Circuit Court of Appeals actually ruled for the little people, and they said, okay, the IRS said that this person owed this, but they didn't put any supporting documents on the record in the form of evidence. There were no witnesses. There was nothing to show that this person was actually involved in this taxable activity, and they have to meet minimum evidentiary standards to actually establish a tax obligation. That was posted by Dan Metter.
Yeah, I read it.
That's the case that you want to rely on, not because it's exactly like yours, because it's similar enough, because it involves the same core issue. When the IRS took that person's property, they did it without first establishing that that person was a taxpayer owing a tax. Because they can't just say, you owe a tax, we're going to take your property to pay it. They had to prove it, and they didn't do that. In my opinion, that case is won, even though it was only remanded for further action, because if they come with evidence now, they withheld that. They withheld that in the first round. So they have no evidence. They have no way to prove that that was a valid taking.
A 60E motion would not get it before a new judge.
No, it wouldn't.
Okay, because I filed a 60E motion and he denied it. So then I had to appeal.
Okay, and is it in appeals
It's still
now?
in appeal right now.
Okay,
That's
I
just wait. And see
that's the
what
route that you have to take. But if you haven't amended your appeal brief, I would do so, and I would actually cite that case.
Oh, I can still amend it because the time limits are all done for filing the paper.
I'd amend it. Let the other side strike it if they can.
Richard, you